because the two words to be able to walk away with it within that song is it says we're going to keep on. And that's the message that we're sending out to each and every bad actor, each and every politician, each and every person that wants to come and impede our quality of life, that it doesn't matter what you bring our way, we are going to keep on walking and keep on talking, and we're going to go arm in arm and we're going to keep on marching. So I want to say to you, good afternoon, and thank you for attending BLAC's What's at Stake series. I am Bishop Marcia Dinkins, the founder and executive director of the Black Appalachian Coalition, or BLAC for short. We are pleased that you have decided to join us today as we learn about the impacts and implications of the Supreme Court eliminating the 40-year-old legal precedents known as the Chevron doctrine. As we all may or may not know, this decision could greatly affect everything from environmental rules that aim to limit air and water pollution, safeguard people from the harms of toxic chemicals, protect endangered species, advance the transition to clean energy, and tackle climate change. The goal of the What's at Stake series is to create a space to think about how our work will be impacted and strategize ways to scale up our collective power to push back in these unprecedented times. Joining us today is Attorney Brooke Christie from Fairshake and Dr. Patricia DeMarco. Brooke Christie, a recent Pitt Law graduate, hey, congratulations, Brooke, joined Fairshake staff in September of 2023 as an Equal Justice Works Fellow who is dedicated to providing direct representation to tenants experiencing lead exposure while collaborating with community organizations dedicated to the prevention and remediation of lead exposure within the Appalachian region. Since joining Fairshake, Brooke has worked with community partners to discuss potential collaborations, including helping to draft model municipal ordinances, assisting with community education programming, creating Know Your Rights guides tailored to localities, providing technical support for organizations receiving federal funds for lead remediation, and accepting referrals for tenants seeking legal counsel. With generational roots in Appalachia, Brooke is excited to combine her community organizing experience and legal education to foster equal access to environmental justice in the region. Dr. Patty DeMarco is also joining us. Patty is a community activist, former elected official, and author. She has authored Pathways to Our Sustainable Future, Global Perspective, In the Footsteps of Rachel Carson, Harnessing Earth's Healing Power, and her newest book, Reimagine Appalachia, Healing the Land and Empowering the People. She is also a senior scholar and adjunct faculty member at Chatham University, a principal of Main Street and Associates, Braddock, PA. She serves as vice president and on the board of trustees for Phipps Conservatory and Botanical Gardens, and is a trustee for the Allegheny Land Trust. Everybody, let's welcome Attorney Christie and Dr. DeMarco, who will share more about how the conservative majority on the court may have cracked the very foundations of federal environmental and public health protections beyond repair. Welcome, Brooke. Welcome, Patty. And I turn the floor over to you, Brooke. Thank you and welcome.
Thank you so much for the warm welcome and for hosting this space for us today. I'm going to go ahead and share screen. I will state that after I share screen it'll go full screen, so you'll have to let me know if folks have great questions in the chat. So just before I begin, I do have to provide a quick disclaimer. I see that you see my face in the bottom of the screen. I didn't know it was going to automatically do that. A little bit about Fairshake. So you heard a little bit about the work that we do, but our mission is really broad and it's very client-centered focused work. We believe that all communities should have access to the tools of change and that communities should have the right to make decisions about their air, water, and the places where they live, work, and play. So while our mission is to serve that entire Appalachian Basin, we're primarily located in Pennsylvania, Ohio, and West Virginia. And in addition to providing direct client representation, we also do community work such as, workshops like this that give background on information and even more tailored experiences, such as, working hand in hand to draft municipal ordinances. Everything in this presentation today is just for general informational purposes only. It should not be construed as legal advice and it does not signify the formation of a lawyer-client relationship. If you are able, you can scan the QR code, and that helps give us an idea just of where folks are on the spectrum of understanding Chevron. You can feel free to fill that out. It's very brief while I provide this presentation. So what is Chevron? It's a landmark case created in response to an environmental question about how to interpret the Clean Air Act. The implication of the Chevron deference was extremely expansive. And what it stated is that the courts would only give deference to agencies when the following two conditions were met. It would be that first, the ordinance was ambiguous, and then second, the agency's interpretation of how to resolve that ambiguity was reasonable. So it's not like the courts didn't have a say. They could state that the statute was clear, it wasn't ambiguous, and they could make a ruling. I'll bring that comment back up later, but in this limited circumstance of when it was ambiguous and the agency's interpretation is reasonable, the courts would defer to them. And that's what Chevron deference was all about. And the application of it was extremely broad. I mean, it touched on everything from immigration, taxes, education, national security, agriculture, and more. If you can think of an agency, everything that they did was usually interpreted by the courts under Chevron deference. So why did we rely on it for so long? Why did we feel the need to give agencies this deference? First and foremost, agency expertise. Judges are experts in the law, not in everything that comes before them. These statutes get very complex and technical. And just to cite some of the examples that the dissent, Justice Kagan, did in the case that we're talking about today, what makes one population of a fish distinct from another, right? That was an example of where Chevron deference was applied, and it was applied, and the judges were supposed to give deference to the Fish and Wildlife Service. Another example was, when does an alpha amino acid polymer qualify as a protein? Again, extremely technical, right? And that was something where a judge shouldn't be, in my opinion, ruling on that. They should be giving some deference to the experts in those fields, which was the Food and Drug Administration. The second reason is efficiency for courts. This is extremely difficult concepts to understand, especially without a background in biology or whatever else you may need to understand the question. So it was efficient for judges to say, yes, we're going to defer to the agency experts in this case. And it really reduced the burden on courts and prevented extreme lengthy litigation about questions that they were not experts in. And another and very important one is consistency. Within our judicial system, we have different districts. One judge may rule on an issue and say, yeah, that population of fish is not distinct enough based on the evidence presented to me. And in a different district, a judge may say, actually, it isn't distinct. They are the same and should be both protected by the same law. We didn't want that to happen. We wanted uniformity for our federal laws and regulations to be uniformly implemented across the country. And so consistency was another reason for the implementation of Chevron deference. And then finally, separation of powers. Chevron deference respected the separation of powers by recognizing the role of executive agencies in implementing laws, as opposed to judicial overreach in policy decisions. It acknowledged that Congress is charged with has charged these agencies with administering the law, and thus granted them the authority to do so. However, of course, as we know, that has all changed since the Loper case. Loper was an Atlantic herring fishery company, and they were bringing this case against the U.S. Secretary of Commerce. The law that was at issue was the Magnuson-Stevens Fishery Conservation and Management Act. Very long, but what really you need to know is that this law stated that the U.S. Secretary of Commerce was allowed to sanction vessels when they did not pay observers on their boats, and these observers were needed, as Congress stated, to prevent overfishing. It's just a regulatory issue. The regulation at issue was when, under the Secretary of Commerce, the National Marine Fishery said, well, in limited circumstances, we're going to also require them to pay for an observer. And we have this authority because in the law, it said that they were allowed to sanction vessels for outstanding fees. There is definitely an ambiguity there, and that's why this case went before the Supreme Court. And that is when the Supreme Court basically, rather than just ruling on the ambiguity of the statute, said none of this matters because we don't have to defer to the agency interpretation at all. They stated in their opinion that agencies are not experts, and this creates extreme pitfalls for our legal system. Now today, judges will no longer have to defer to the agencies. They may argue, agencies may still argue that their interpretation is correct, but they have an extreme burden of persuasion, right? It goes back to trying to persuade a judge who is not an expert in these fields that they are correct. So it is a much higher burden and it's much more difficult, and the judges do not have to rule in their favor. So we have policy uncertainty. With less deference to agencies, there will be even greater uncertainty in environmental regulation, complicating advocacy efforts and long-term planning. You will have increased judicial involvement. I've spoke about that quite a bit, of just that they will be the final decision makers. My biggest concern for that is also the fact we will have less predictable rulings across jurisdictions. I mentioned earlier the fact that we have different districts, right, throughout the country, rather than an agency interpretation just being held valid or invalid. You will now have judges across the country stating whether or not it's valid or invalid. So you may have a judge in the DC area say, yeah, this looks okay, but then a judge in Texas say it doesn't, causing implementation of laws to be different around the country. And of course, potential for slower action. It will cause a lot more expenditures to be spent on expert witnesses, just sheer time trying to explain these issues to a judicial system. And of course, what that delay results in is negative impacts on communities, and inconsistent enforcement. So what are some potential next steps for environmental advocates? I've attempted to identify 4 broad buckets, but these are by no means the limits and by no means must-dos. You can focus on one or others. Within the court's ruling, they overturned Chevron because of a federal law called the Administrative Procedure Act, which is arguably where agencies were getting all their authority to make this decision and to grant them that deference. You could amend the APA, Congress could, to specifically state that, yeah, we actually did intend to give agencies this deference. The second thing I would highlight is that not only does the federal government have an Administrative Procedures Act, but states do too, and they almost always copied the federal government's law. It's a lot easier that way. If you think the feds did it right, you might as well pretty much implement it at the state level. So to prevent that domino from falling, and I'll talk about this more in detail in a later slide, but you could also have the states update their Administrative Procedures Act to really protect states' environmental enforcement. The third and the biggest ask is to try and identify which environmental protections are most important to you and see if you think they're at risk. And that's not an easy question. Even us lawyers don't have an exact answer to it. This is a 40-year precedent that we have relied on for 40 years in our country to write laws. Overturning it, we're not sure what it means for the future, right? So we have to work collectively to write those answers. And collective action. You know, I'm talking a lot about the judicial system and our judges, but we need community involvement. We need our executive officers at the table. So your mayors, your governors, the president, right? All at the table as well. And our legislators to assist in drafting laws to make these protections codified. So bucket number one, the Supreme Court found that agencies did not have, Congress did not authorize for agencies to decide relevant questions or interpret statutory law. So I mentioned this earlier, you could modernize it, provide that expressly. I do want to put a caution sign on it. As you know, our current Supreme Court is not friendly. So there are maybe some legal experts, and I put, you know, in small, you all will get these slides after and you can digest them because it is a lot. Some notes at the bottom, but basically some legal experts may not want to do this because they're scared of the answer that the Supreme Court will have if you challenge it. So this is an option. You can amend the Administrative Procedure Act to give that express authority, but what Congress will, or what the Supreme Court will do with that is questionable. So some folks may push back. The safer option is likely to pressure state legislators to ensure their agencies have deference in state law. It is my opinion that I think a lot of the environmental enforcement that we see go on is through our state Department of Environmental Protections. And so ensuring that they have full broad authority to make those enforcement actions, it would be prudent to update those Administrative Procedures Act to ensure that our state Supreme Courts do not follow suit with the US Supreme Court. It can cause that legal domino effect that I mentioned earlier. If the federal Supreme Court says one thing, the state Supreme Courts are likely to follow. We haven't seen that yet, but it's good to get in front of it rather than be reactive to it. In these slides, I've specifically mentioned both the Ohio, Pennsylvania, and West Virginia Administrative Procedures Act, just to show that every state has one and they are very similar to the federal language. And then bucket three, the harder one that I mentioned. Identify which protections are most important to you in your community, and then try to have discussions about how you can ensure those protections are not going to receive Chevron challenges. So what are environmental protections? They could be any statute, any law, regulation, that's what the rules that our agencies come up with, or action. It could be a governor sending a letter to someone telling them that they want them to cease action. Designed to preserve our natural environment from harmful human activities or safeguard human health. So I tried to give a bunch of examples of this, right? Because it's very legal and technical, but the air quality, you know, if I know air quality is really important to me, I would look to the Clean Air Act. That's a law. And then some of the regulations that are really important is like new source performance standards. Again, super technical, but it basically says how much pollution is legally allowed and what levels are not. And so you could go down the list like this. If greenhouse gases is super important to you, climate change mitigation, you have the law, the Clean Air Act, and then some of the regulations that are really important are like the emission standards for your vehicles. What is going to be challenged is not the law, but all the ones that are linked in this slide, the regulations. You need to make sure that the regulations, the agencies have express authority. If it's not super express in the law, that's what's going to get challenged. I did try to provide an example of this. If this feels overwhelming, I do want to pause it just right here to say that if it feels overwhelming, it's probably because they want it to be, right? This is 40 years of statute and law that is being thrown out the window, and we're just trying to shuffle papers around and figure out how to deal with it. So how do you tackle a big problem? Just one day at a time and one step at a time. Even Justice Kagan in her dissent, because she disagreed with what the Supreme Court ended up doing, said this will cause a massive shock to the legal system, casting doubts on many settled constructions of statutes and threatening the interests of many parties who have relied on them for years. So we're all in this together, and we all can collaboratively work to start to address these issues. I did make an example. PFAS, right? That's front of mind for a lot of people. If you're not familiar with it, basically these are chemicals that cause cancer, and we're finding out that they are everywhere in our economy, from cosmetic lines to sometimes even foods, clothes, things of that nature. So PFAS's designation as a harmful contaminant is important to protect our communities. We want to make sure the agency has authority to take action. So then that was my brainstorm. And then I identified, well, what law is PFAS regulation under? And it's under a couple, but primarily the Comprehensive Environmental Response Compensation and Liability Act. CERCLA for short. A lot of folks refer to it as that. And that's what gave the EPA the authority to say PFAS is harmful. So does the statute, CERCLA, give the EPA express authority to designate PFAS as a harmful contaminant? I went ahead and pulled up the statute for you and highlighted some things. But most importantly, it says administrators shall, administrator being of the EPA, shall promulgate and revise and designate hazardous substances. This is pretty clear that they have the authority to designate a hazardous substance. So I would argue that this is not a ripe, something that could be challenged by Chevron. I think a lot of corporate lawyers have a lot of money and they'll do a lot of things, but I think this one's pretty safe. And then it also says they can determine the quantities that should be reported for these hazardous substances. So it also shows that they have that authority right there. This is one that I would argue is safe. Now, how they handle it, as in how they are allowed to make enforcement actions, that might be another question, but they can say that PFAS is unsafe. And I wanted to give a completely different example. This is one that I do think is going to be ripe for challenge. The EPA improved lead and copper rules requirement that all lead lines be replaced in 10 years is important to protect Appalachian communities. That was something I brainstormed. We do expect the improved lead and copper rule requirement to go into effect. And it does say that in 10 years, most cities have to update their lead lines and get rid of them entirely. So the second step is identify which law gives them that authority. And it's the Clean Water Act. That's what gives the EPA authority to say you need to update your lead lines. So now my question is, does the statute give EPA express authority to require lead line replacements? I pulled this up again, and the biggest statement in here is that when creating rules like this, that lead lines need to be replaced, the administrator, their decisions have to be economically achievable. That is a big red flag, because what does that mean? Congress did not define it, unfortunately. Economically achievable. This is a huge cost to replace lead lines in 10 years. There's industry hurdles on hiring, supplies, all kinds of things like that. And so I looked at the regulation on the right-hand side of what did the EPA say when they said lead lines were going to be economically achievable, these replacements. And this is a big text, but long story short, they thought about a lot of things, like the cost that communities bear, right, when lead lines aren't replaced, the fact that children are being poisoned, the fact that the cost for filters and all these other things that these costs that communities bear. It never says in the law that these external costs, I'm going to put big quotes around it, but that those should be considered. I believe they should be considered, but unfortunately that is nowhere in the law, and that is the agency's discretion as to whether or not those costs should be considered when justifying whether it's economically achievable. Basically, the EPA is saying communities pay this amount all the time when we don't update lead laws. So even though it's a huge corporate cost, it is achievable. It's a balance, right? I don't think all the courts are going to say that. They're going to say that is nowhere in statute. This is a huge corporate cost. We're striking your rule. So it's something that I think the federal government has to get in front of in various ways, whether it's passing a law to directly address it, and give that express authority for this consideration. But right now it is just nowhere in law. And so that's where collective action comes in, right? We know these things are important to us. If they're not expressly written in the law, sadly, they are going to be challenged. Corporate lawyers have a ton of money and a lot of time. So we need all hands on deck. We are on the defensive. And we obviously, with the, as I just mentioned, corporate lawyers have a lot of time, right? So we need all branches of government to help us out. We need the mayors sitting at the table. We need legislators, whether it's your state or Congress members, right? We need community members to be highlighting what is most important to them, because right now there is a lot going on. So the more you're able to use your voice to amplify what is important can help prioritize in what order we start to address this and shift power back to people. I'm just going to go briefly through some of the big news headlines that we've seen. U.S. Air Force avoids PFAS water cleanup, citing Supreme Court Chevron ruling. The crux of their refusal to comply with this order hangs on whether the amount of PFAS in the water is an imminent and substantial danger. We talked about this earlier. It's under the Safe Drinking Water Act. And the regulatory action that was challenged was an emergency order. I have read into this just a little bit. I'm not an expert in PFAS, but a lot of folks don't think that this legal argument will stand up. You know, I mentioned earlier, PFAS, at least the designation of it being harmful, it seems to be pretty strong. But it goes to show that they're going to rely on this in various ways, folks who are polluting, just to delay accountability, right? So even if we have the legal argument on our side, they're going to want to challenge it, because the longer they can keep polluting while something's in the court system, the better for them. Another concern was SCOTUS overturning of Chevron to have credit effects in healthcare. Again, not an expert in this, but I read a little bit about it, which is the Department of Health basically has used their discretion on how to calculate reimbursement and components of Medicare. So because they have that discretion under the law, some folks are going to challenge it. And why? Because hospitals want to be paid more. So this is mostly a headline to show you the expansiveness of the effects. And sadly, this was a ruling in a jurisdiction that the Department of Health and Human Services does not have the authority to protect trans people or kids. This is under the argument that a famous case called Bostock, which said that you're not allowed to discriminate based on sex in education. The Health and Human Services said, well, if you're not allowed to discriminate in education, you obviously should not be allowed to discriminate in healthcare either. And that was their interpretation, the agency's interpretation of that Supreme Court ruling. And a federal court said, no, I am the decider of law and fact, and I don't have that opinion. So you cannot put these regulations on hospitals. And that was a Mississippi judge. Again, this goes to the fact of it potentially seeing issues treated differently in different jurisdictions. I'm sure there are a lot of judges who are itching to have a completely different ruling and rule in favor of the Department of Health and Human Services non-discrimination rule and say that that was proper. But even if the different district says that, it's not going to change the fact that a Mississippi district has this opinion. You would have to get a higher court to make that decision. And so, just some questions, as you're starting to digest this, right? We're seeing a forest, and we also need to tend to the very specific trees as well, right? So what protections are front of mind for you? What other rulings may impact your environment directly? What are some potential next steps that you see? And how can you collaborate with other folks in your region to address these next steps or concerns? Again, this is another, and I'll plug this one in the chat, just another survey to ask how you're feeling about this. Please let us know if you found this presentation helpful or if you have other follow-up questions or concerns. And of course, Fair Shake is always happy to be a resource as you continue to navigate this, because we know it's a very complex conversation, and we're happy to be of support. So now I'll turn it back to you, Miss Marcia.
Marcia, and thank you so much, Brooke, for such an informative presentation. And just reminding us that in order for us to get to where we need to do it collectively. Bridging the gap that keeps us in isolation, social and political isolation, and amplifying and bringing in our collective voices. And that is our hope with the What's at Stake series, and to work with Fair Shake, as we have been talking about, to look at some of these harmful things that's coming down the pipeline. Should be clogged. So many harmful things come down the pipeline. You would think it would get clogged and just kill itself, but not going to happen. So thank you again, Brooke, and we will share the presentation. I'd like to take the time now to introduce to you Dr. Patricia DeMarco.
Thank you. If I could share my slides, I'd appreciate a chance to do that. Let's see here. Okay, can you see that? Okay, I take this ruling at the Supreme Court very seriously, because I think it is one of the more egregious exponents and expressions of the shift in the tone of our governance from emphasis on the public interest, public health, public safety, and the general well-being of citizens at large, compared to the profits, well-being, and freedom of companies to do whatever they please. This case, almost more explicitly than any other I've seen recently, has put the thumb on the scale in advantage of the chemical companies. And I feel that at this point, we are facing an alarm bell in the abandonment of public health as a parameter for public policy. And that to me is the biggest lesson that I see from the Chevron case. It is a real call to arms, in my opinion. And I'll give you a little bit of why. I'm going to go into a little more detail on both of these, but the major consequences of this decision are that the pollution crosses state lines, even national lines, and a fragmented response by pushing the accountability and enforcement action down to the states divides the ability to enforce and gives the companies a chance to divide and conquer state to state. We've talked a little bit already about the technical expertise of specialized administrative agencies compared to local judges, so I'm not going to talk about that a lot because Brooke really went into that very beautifully. And then the public health protections in law cannot keep pace with the production of new chemicals. You cannot write every chemical that is likely to have harm into every law. It would be a constant churn of legislative response to the chemical industry production. So I wanted to remind you that we have chemical pollution all around us, that it gets into our bodies from land pollution, water pollution, and air pollution in a whole variety of conditions, and that all of these are exacerbated by climate change. And to just start with air pollution travels globally. It's driven by the prevailing westerly winds and the rotation of the earth on its axis. And you cannot contain the effects of a pollutant in one area and regulate it locally. The methods of air pollution and dispersion are really complicated. The action of the sun and the wind on the materials that come out of industrial sources, out of mobile sources, out of marine vessels, and out of just the dry deposition of dust from agriculture even. It gives you interactions in the air so that you get new compounds, some of them more toxic than the ones that were emitted in the first place. New particle formation, they're taken long distances and they interact with the water in the clouds and can come down in a different location far from where they were originating. These processes are not easily regulated by a state-by-state action. And you have across the state, across all the states, there is over time low-level exposure to pollutants that really give you endangered public health over a long period of time. You don't have to have an emergency declaration in order to have health harms. As Brooke mentioned in one of her cases, they said, well, this isn't a toxic emergency. Well, chronic pollution over a long period of time, look at all of these deep red areas by county. And look at where you might be on this map. This is an interactive map. If you want to go to it, you can see where your particular county, this is Allegheny County right here. You don't have to have an acute exposure to have health harm happen. And there are a lot of pollutants. From 1990 to 2017, emissions of air toxics declined by 74%, largely because of federal and state implementation of stationary and mobile source regulations that were enacted in that improvement to the National Air Quality Act. It has had an effect. However, nevertheless, 85 million Americans are exposed to at least one toxic air pollutant on a regular basis. And there are thousands of facilities, 12,000 facilities that house extremely hazardous chemicals in amounts that could be harmful if they were released. And there have been, even in 1 year, measured from 2021 to 2023, there are roughly one toxic hazardous chemical incident every 1.2 days. And there have been deaths and injuries, and more than 200 communities had to evacuate from these accidents. These kinds of, things cannot be regulated on a state-by-state or individual community basis. the long-term effects of health exposure to air pollution are not disputed. What you have is pretty much a huge concentration of the population. Millions of people have respiratory symptoms, and hundreds and thousands of them have severe conditions that cause absences from school or work, hospitalization, or even death. So this is not something that is easily dismissed. We have an urgent problem needing better regulation, not fragmented regulation. Likewise with water, we have major watersheds that cross not just national boundaries, but international boundaries as well. This is only one, this is the Great Mississippi River drainage. It covers almost a third of the United States. And you cannot expect that pollutants in one place are going to be contained there if they're not properly managed. Waste from the oil refineries and from plastics and chemical manufacturing, including forever chemicals, can get into streams, rivers, and lakes. They also, by the water supply, go into soil and crops and end up in our drinking water. And there are also pipeline incidents that cause spills, which create accidents from just aging of these facilities, but also from human error and from the ubiquitous nature of these pipelines. This is definitely not a state-by-state regulatory problem. And you have definitely well-defined risks from exposure and health harms from water contamination. These are not things that are, disputed, and they've been associated with fracking. They've been associated with refinery water pollution. And these are things, again, that you cannot leave to the discretion of the states in a state-by-state basis. And the worst thing is that there are new chemicals produced daily. There are 80,000 chemicals estimated in commercial use. About 2,500 of them are in high production volume, but only 200 have been evaluated for the toxicity and safety or health effects. And about 2,000 new chemicals are introduced annually in the US into commerce. And only a few of them are tested in advance of being into the market. You usually allow the industry to determine whether or not there are toxicity effects associated, and the Toxic Substances Control Act is one of the weakest of our environmental protection acts. There are about 7 new chemicals introduced into our environment every day for commercial use. And the forever chemicals in water supplies, this has been documented by the United States Geological Survey, and they find that there are 5,021 locations in all 50 states that are known to be contaminated with these materials. The EPA has proposed regulations under the Resource Conservation and Recovery Act, which Brooke discussed a little while ago. But again, you can see that if these are challenged now, and the Chevron case gives you the ability not only to challenge new regulations, but to challenge existing regulations that have been on the books for years. You now have the ability to say, oh, the Endangered Species Act is compromising my economic activity in this old growth forest, or I'd like to be doing some fracking extraction of water from this stream, and there's a fish in it that maybe I can challenge the designation that prevents me from using that water supply. You have the ability now to open and unstabilize regulation that has been in place for decades. So my concern here is that we really started regulating air pollution in 1955, and that happened, it took years after the Donora killer smog of 1948, where 20 people died and more than 7,000 became sick because of the air pollution. I grew up in Pittsburgh when the air was so polluted that the lights were on at noontime. And it's really not something you want to go back to. As it is, 1 in 12 people in the US have asthma today. That's over 27 million people. And we need to have better accountability from industries for the health harms of pollution, not worse. And if you look at the Pew Research statistics about the opinion of the public about environmental protections, you find that people want better environmental protection. People are concerned about the contaminants that they are exposed to in their daily lives. And yet, if you look at it on a demographic based on political party, 80% of Democrats have this as a priority and only 30% of Republicans. There's more concern for the cost compared to the environmental benefit. And this to me is not a cost benefit type of thing. When you're talking about 1 in 12 people having asthma and many of those being children, it is really not in our best interest as a country to compromise the public health and safety of our population for the sake of economic benefits to particular discrete industries. So I'll stop there and we can proceed to have a conversation.
Thank you so much for that, Patty, and just breaking it down in such a way that we can all understand it. And I see where some folks are like, giving the emojis where their heads are blown because it's like 7 new, chemicals introduced every day. So what we would like to do at this time is open the floor for any questions that anyone may have. And Milan Bush, who is also with BLAC, will call upon you. And I'm not sure if there are questions in the chat. We can also, address those questions in the chat.
Absolutely. Thank you, Bishop. Yeah. If you have a question and you would prefer to just say it, you can either raise your hand or come off of mute. If you prefer to put it in the chat, we will take that. I see that there was a question asked from Brooke, but that was answered by Brooke in the chat. But if anybody else has questions, feel free to come off of mute.
I would like to just add on to the question a little bit. So to restate it, they asked, would this decision render interstate commerce unworkable? Is that an area of attack or argument to overturn or change this decision? Certainly some industries will be negatively affected if there's different jurisdictions saying you can do one thing and another one saying you can't. I think a lot of folks will fear, though, making that legal argument because of the current composition of the Supreme Court, not just being friendly to any, what I would argue more logical decision making. But what I wanted to highlight on that is that courts are reactive. To even bring a case in court, somebody has to be harmed. I mean, that is a pillar of what we call standing. To stand before the court, you have to have an injury. So I just wanted to highlight that while we may be able to make some legal arguments to quote unquote, like stop the bleeding, right, of like what's happening right now, I really do think some other ideas about how we can work collectively to write laws or to pressure presidents or governors to make changes. I think that's the better way to go and focus your energy because courts are simply just reactive.
As a follow-up to that, since I asked the question, I'd just like to say that it does it presents an opportunity to power map the problem as well, because we have many interstate companies. I mean, honestly, I can't think of anything that will not be affected by this decision, any industry. For example, how will insurance work from one state to another if there are different decisions? How will bottled water bottled in one state go to another state, and if there is a different standard? There's nothing that will not be addressed by this. Food, there's very little. So you have an opportunity to power map and to go to those industries and start raising these concerns and have those powerful industries saying, oh, maybe this wasn't such a great idea. Just a thought anyway.
Beautiful thoughts, Sally. Thank you. I'll pass it to Jennifer now.
Thank you so much for these really clear presentations. And I was just wondering, it's so overwhelming, and a step at a time is indeed good advice. I was wondering right now to just introduce, these major reforms that we need to do to help the attack on democracy, of which this is just another major part, and how we can get the word out, connecting it to going forward in the election. One thing I wanted to just ask you all is if you're, familiar with how corporate personhood as a reality that I used to work for Move to Amend in the past. How does corporate personhood play into this reality as it is legally evolved over time? And should we be renewing that kind of catch-all kind of movement building to actually get some of these bigger amendments with the Supreme Court? I know you're not supposed to advocate for specifics now, but we now are, we've had these big reforms. Like, what about voting rights? What about the ability to regulate money in politics? Well, my understanding is, and the lobbying, which is leading to these kind of decisions as the courts have become influenced by big money too. Is corporate personhood something that you could see as fighting for in conjunction with this kind of massive thing to help protect us going forward and reworking the public interest piece of what government is supposed to do? And what kind of movement building do we need to do here locally and at the state and national levels? And thank you for underlining too, Patricia, how important federal regulation and process is. Thank you.
Patricia, did you want to try to touch on that first, or?
Well, I think it's important to recognize that, corporations have now been given personhood under the Citizens United ruling. And when that happened, I was really in despair because I felt like we really lost our country. Corporations don't breathe the air. They don't drink water. They don't have children who are affected by endocrine disruptors or anything else. They don't bleed. They have no personal stake in the future, just money. And when you have a policy system that's driven increasingly by strict economic factors that don't include any of the externalities that make us, part of an environment, part of a health system, then you're going to get absolute economic determinism, and that favors corporate laissez-faire. The market will not control these things. You need to have regulations to protect people as people. And the Citizens United giving the corporations the power of personhood has given them standing in cases where they would not otherwise have standing. I'm not a lawyer, but that has been my observation over 50 years of battle.
Yeah,
I'll just,
I was thinking. Go
yeah.
ahead.
I was just going to expand upon it and say that, while I think it's true corporations will sometimes be negatively affected by this ruling, they will predominantly benefit by it, right? The ambiguities across state line, yeah, we might say that makes, logistics more difficult, but they also are served by it because they can hide in the ambiguities. They can hide their pollution in that gray space. And if they do get caught, well, they just say, oh, well, we didn't know any better because Mississippi said we could do it. So, and, California hadn't ruled on it yet. So we were just following the other court opinion. So yes, they will sometimes be negatively affected by it, but they will benefit more. And so I do not personally find them to be an ally in this work at all. I think in rare circumstances it can happen, but it will be rare. And unfortunately, when those cases occur and they might be able to collaborate on a case or something, it will be limited, right? Their fight is not for us, their fight is for profits. So it will be a limited circumstance when they are able to work with us. Now, all that being said, there's an argument of benefit corporations and somewhat of a movement going on in this country, but it has not taken hold to a large extent. And benefit corporations basically say, rather than just trying to make a buck, we're also going to try to improve the world, right? And it allows you to expand your view to include workers' rights and other things. It allows them to do right, but it doesn't make them do the right thing. So, there are some good corporations out there. I would point to some benefit corporations like Patagonia that try their best. But yeah, I just don't think most corporations fit that mold.
Thank you so much, both of you.
Mm-hmm.
I noticed, oh, I'm sorry, Jennifer, did you want to ask? Go ahead.
Yeah, I'm just gonna write in the chat to stay in touch because I'm new, like a year old in Pittsburgh, and I wanted to revive my democracy reform engagement, which does have some data, around how many percentage of people think that the overturning Citizens United and corporate personhood are among the top reforms we need in the democracy crisis today, which touches on all the other crises we're having, equity, environmental, etc.
Because there was a question in the chat by Anita Jade, and I'm going to get back to it just a second. And she had asked, typically, how many environmentally impacted people are enough to make a case? Did you want to tap on that? And Anita Jade, if you want to flesh that out anymore, let me know too.
I'll just quickly say all you need is one. As a lawyer, we only need one person to be harmed to bring a case. However, of course, the more folks that are impacted, the more we can bring light to what is actually going on. But really, we only need one person. So if you know somebody who needs help, I encourage you to send them our way. And if Fair Shake isn't able to directly represent them, we also can try to provide referrals to other friendly lawyers.
The difficulty with these environmental kinds of cases is that it's really hard to prove that a specific company's chemical made a specific person sick in a specific way. The epidemiological data is often full of holes because you can't do, blind test controls on humans. So if you say, for example, I was exposed to PFAS and my kid is now, affected, and so I was genetically harmed, you can't prove it, because they'll say, well, you were exposed to 20 million. Oh, do you smoke? Do you take drugs? Do you do this, that, and the other thing? It could have been 15 million other reasons. And because we are exposed to a chemical stew, it's really hard to isolate how a particular company can be held accountable for a particular action. And it's very, even in the case of the highly abnormal brain tumors that were in a community affected by fracking, the company just kept expanding the area from which you collected the data until they got below statistically significant numbers. And the plaintiffs could not argue that that wasn't an appropriate or legal way to define it because there were no standards for that. So it's very difficult. And sometimes you can do a class action, like there's one going on for talcum powder causing fallopian cancer, all kinds of things like that. But the burden of proof, unfortunately, is on the victim, not on the company. And it should be the other way around.
If I may, Milan.
So beautifully said. Oh, Bishop, yeah, go ahead.
No, go ahead. I just wanted to. So I think part of part of Nita Jade's question is how, you know, what I'm hearing is from a community perspective, what does it take to build this collective power? And Brooke is right. It takes one to bring a lawsuit. But if we're looking at this from a community perspective, it's going to take more than one. And that's why we use the word collective power or community. And it depends. I've heard there's, you know, one of the things Brooke brought to the fore that BLAC is going to bring people back into and tap on Brooke's shoulder again, and Michael Parker's is this question around what do you care about? And then how do you analyze what you care about? And in organizing, we call that a research action. And so one of the things about a research action is you're doing just what Brooke mentioned. You're pulling up information as Patty mentioned, but then you can bring, you know, and then you identify, I heard someone mention like power mapping, because you have to determine who can give you what it is you need. We don't arbitrarily just need to go out there and say, oh, because it's a federal government issue, we really need to be at the federal government level when, you know, Brooke has said, nope, we don't really need to be there so much. Look at your state level or look at your local level. But in a research to action, just hypothetically, you have identified your mayor, and your mayor is the one who you can start the conversation with. Your mayor is the one who could possibly give you the direction. In a research action, you can take 20 or 25 people. And what you do is you have to get comfortable with a couple things. Number one is silence. And number two is yielding, you know, it over to maybe one or two people to have the conversation. Why do we do that? Because what we've lost in the element of organizing, which is by numbers, is this element of our own power, our power through our silence and our power through our numbers. And so a research to action, Nita Jade, it could be 10 people, 20 people, 25 people. You never want to go anywhere alone when you're doing the community work. Secondarily, we have built actions and taken direct action and have put 1,500 to 3,000 people in a room. So it just depends. And what is going to need to take place now to get to these numbers? Number one is having a set of people who you can really invest in. And a lot of times we call that a core team. And that core team could be 10 to 12 people. And that core team is getting educated. But within that core team, that's when we start building out our numbers. So if I have 12 core team members and each one of them are trained, then I can say, I want each one of you to do a training and each one of you bring 10 people. And so that's 120 people. And then you ask each one of them to bring 3 people. And what is that? 60 people don't, you know, check me on my math. But the point of the matter is that's how we begin to build up this collective power, because it is, you know, it's 2 things, 2 rules of thumb. There's organized money and organized people. If there's anybody who has $1 trillion on here, please, we ask you to come and to support the movement. But if we don't, then we have to realize that our stories are currency, our voices are currency. And what we begin to do is to build that power. So yes, it can start off with one in the legal realm. And really, if we're really going to do this and build this collective power, we should also be connecting the community organizing to what Brooke is doing to elevate the voices. And so we shouldn't have any empty spaces. And so it can go from 1 to whatever, you know, however many people that you can build this collective power with. And also sometimes it depends on what you're trying to do. Again, a research to action, you can put 10, 20 people in a room, bring your information to the fore and kind of start having your negotiations. And if they don't want to do that, then you really start having to build that power even more so. And we do it through a process. I've been long-winded enough, but just to answer that question from a community perspective, it is going to take us coming together and really thinking about who else cares about what we care about and how do we bring them in and how do we, you know, keep them in such a way that they are not only invited, but they are welcomed in the fight and they see themselves in the fight. This is a wrestling match. And I get to say, after I get tired, I get to tag Patty and say, tag, you're it, you know, and we need to be able to build power to say that, because all of this is an ecosystem. They all connect one to another. We are not in 50 different fights. I close with this. We are not in 50 different fights. We are in one fight with 50 different rounds. And each one of you bring an expertise and a wisdom and a knowledge and a story and some power so that we can look to you and say, tag, you're it. And then we support you as we begin to, build our collective power to raise our collective voices.
And I say to that, wow, just very insightful from all of you. Again, as Bishop talked about, building that collective community power through our knowledge and learning at what's at stake. And a couple of things that I really enjoyed hearing from the conversation was when, Patty, you talked about better regulation instead of the fragmented regulation. And you mentioning the circular brook and power mapping as well. And, the fact that our laws can't keep up with the chemicals, but also making people aware and giving power to their voices. I wanted to ask if anybody else has any questions as we continue these conversations. I think it's, I'm seeing people say thank you. But just wanted to catch if anybody else is.
There is one question in the chat.
Before we read that one question, I just wanted to add on, you were discussing a minute ago too, what are the goals? So I just wanted to add on and elaborate from a legal perspective that that's the first thing Fair Shake asks folks when they come to us is, what are your goals? And we might hear things like, get our money back for medical costs, or stop the industrial operations, or sometimes it's just to have your day in court. Patty talked about how winning is difficult, right? And that's very true. The medical experts that we bring in, it's always easy to try and, establish like they're not credible or that there's a hole in this argument. And it might have been something else that caused your condition. But to reach your goal, whatever it might be in either individually or in a community group, it might be just to hold them accountable, right? I mean, a court is public record. We can help highlight that on a bigger scale. It might be to negotiate to get your medical costs. Those kinds of things are possible. So I don't want you to feel defeatist of the fact that sometimes things aren't always on our side. And that's very true. And we have to be real with you on that as it is legal counsel. But we can also help navigate those difficulties so that we still help you reach your end goal as much as possible. So I just wanted to highlight that, that small wins are still very much possible. It just, we might have to compromise on things here and there.
I'd like to just say that most of our major environmental regulations were adopted in the 1970s. And if we should find ourselves in a favorable congressional and administrative environment, it might be time to update these things, to consider the interaction among chemicals once they get into the air or the water, and to begin looking at the system effects that we're experiencing and maybe reshape and reinforce some of these regulations that have, they've been tested over time, and maybe there are some things that we can just improve across the board systematically. I don't know if the time is right to do that right now, but it certainly has been accumulating little cuts over time. And it might be time for a national discussion about what do we really think about the value of our environment as a condition of our existence. How much is it really part of our quality of life to be able to breathe clean air and not worry about what's in the water and not worry about what contaminants have been added to your food? Wouldn't it be wonderful to not have to worry about that on a daily basis every time you go shopping or go outside?
Thank you, Pat. Because we had one last question.
It was from
Trying
you.
to get to the question.
Here, she says, when will they start
Bishop, could you help me out? I can't.
Yeah. When will they start to
Go ahead.
assess cumulative impacts and regulation? It's so frustrating. So it's a question and a like, hey, I'm just
Yeah,
back. Oh. And that was from Yvonne.
I'll briefly
Let's
state
see.
that I do know the EPA has started to assess cumulative impacts. So it is starting. I think Patty could probably speak to the science of it a little bit more, but the problem I see in legal sphere is while it's started, getting experts to speak to it in court is sometimes difficult. And even this is a start of a conversation, right? So from a legal standpoint, reaching that burden of proof is difficult. And so to your point, I think that's also when we think about where to push, right? Executive could be a great place to push. Like we need to refine more of that science and have that conversation on a greater scale. And that would be a great place for an executive like a governor or a president to lead on and continue to lead. But from the court system, it's still pretty inadequate for burden of proof. We bring it up for sure because it's very relevant and it is scientifically supported, but they can push back on it. So I'll turn it over to you now, Patty.
Yeah, I find that since really 1986 forward, science has been more and more systematically discredited as a basis for public policy. And you have seen the, really diminishment of scientific evidence as a legal point to rest on as a result. Just because the laws of nature are not negotiable doesn't mean that in the court they are not negotiable. You have people who define by law, like in places like North Carolina, where they say you cannot put information about sea level and tide level in your real estate notices. Because they don't believe that climate change is real and they don't want to compromise the real estate value of shoreside property. So when you have people, basically operating in denial of, widely recognized science, you really are facing a very different problem than just whether or not it's in the public interest. And I think one of the things that alarms me the most, as I said at the beginning, is that, laws are supposed to be made in the interest of the public, of the general well-being of the people. And when they're tipped too much to the point where it's the well-being of corporations alone, then you're open to all kinds of damages that are very difficult to reverse.
Thank you, Pat, for that way to end our conversation about what's at stake with the Chevron decision. We at BLAC, again, thank you, Pat and Brooke, for giving us such vital information and the ways that you've done it to make us have better understanding and thoughtful next steps in this process. We at BLAC invite you guys to continue the conversation with us. We definitely have ways to stay connected. There is a petition that you guys can be a part of as well. I'm going to put that in the chat. But I'm going to turn that back over to Bishop to send this out.
Thank you, Milan. Again, just wanting to echo what Milan said, thanking you, Brooke and Patty, for bringing your wisdom and insight into the space. And for those of you who want to learn more about them, I'm going to ask that Patty and Brooke, put their website information, social media, and LinkedIn information in the chat. We will also share their information, with you when we share the slides, and we generally do a little toolkit afterwards. But as stated earlier, BLAC is hosting a What's at Stake series. Chevron is the first in the series, and starting in September, we will start holding conversations about Project 2025 and how it will put people and our planet in peril. Moreover, this Project 2025 policy playbook threatens to reverse progress and return to policymaking that prioritizes fossil fuel profits over our well-being. So it is imperative, and I can't say it again, it is imperative, it is mandatory, it is super necessary, and you can put all of those words in there that says it's a must needs, that we amplify our voices, share our stories, and shift the power. To do this, BLAC will help, will create and share talking points, and these can be replicated. We will also do regional power mapping to create and analyze what we care about and create ways to take collective action and amplify our voices for change. In addition, we want to do some scenario planning to the ways we must build our movements and push against the continued attacks on our democracy and our quality of life. I would also like to extend an invitation to you. On the third Thursday of every month, BLAC holds its Petrochemical Lunch and Learn series, where we talk about the health harms or health as a human right. And they're held from 12 to 1:30. The next one will be on September 19th. And joining us will be Dr. Jalan White Newsom, the director. What is she? The director of EJ40 Initiative for the White House, and Sonia Kakiri from Emerald Cities Collaborative. And you don't want to miss that. Patty will also be joining us. And again, ways to get involved. It was stated we can pressure the state agencies to ensure that they have deference in the states. We want to bring people back together so that we can have these conversations about what's at stake for you, what's at stake for your family, what's at stake for your community, and what's at stake as a whole. To learn more about BLAC, you can go to our website, blackappalachiancoalition.org. You can also find us on Facebook, X, Instagram, and other. You can also find us, our podcast, BLAC Remembering, highlighting the heavy and the hope, pretty much just on all the podcast platforms. And we also invite you, if there's something that you want to share, you have a story with regards to petrochemicals, fossil fuels, or the harms within your community, or as one individual talked about, she has information about democracy. We welcome your voice, to be on our podcast. I want to also thank, we don't call ourselves a staff. I want to thank the BLAC family for being a part of this and making this first discussion, what's at stake discussion, a success. But more importantly, I want to thank each and every one of you, because without you, we would not be successful. So remember, our goal is to just join hand in hand and heart, voice in voice, because we want to make a collective sound. We have a collective story to tell. We have individual stories to tell. But more importantly, we want to build collective power. We don't have to stay in the pain. We can get on purpose and build that power. We can move to a place where we can see the low-hanging fruit and just remind people that there is hope. What we need more today is not just love, but what we need also with love is hope. And so let us be the change agents and the voices to bring forth that love and that hope so that people can see the future that they desire, not only for today, but for their future. We're building legacies, and we don't want to leave legacies of pain. We want to leave legacies of hope. We want to make sure that our children and our children's children know that we care, and we are protecting their life, the land, and the legacy. So thank you again for joining us, and we hope to see you at our next Lunch and Learn, September 19th. We will also again send out this information to you, the recording, the PowerPoint slides, as well as the sign-on letter and any other information. Any questions that you have, please feel free to reach out to us at helloblack@blackappalachiancoalition.org. And what I want you to do is to remember to be like water and to flow in somebody's life and to smile, because I heard it's contagious. So put a smile on your face or put a smile on someone else's. Have a great and wonderful day. Bye, everybody.